All right, welcome back. Our next panel is called Managing the GDPR After a Data Breach, and this is a fantastic panel. Let me start with our moderator, Patrick van Eecke. He is a partner at Cooley. He is based in Brussels, our second Brussels person of the day. Awesome. Patrick co-chairs Cooley's global cyber data privacy practice. He has more than 30 years of experience guiding clients on complex issues spanning data protection, cyber, electronic commerce, digital advertising, and electronic signatures. Welcome, Patrick. Very pleased to welcome Edward Machin, a counsel at Ropes and Gray. Edward's based in London, and he's counsel in the Data Privacy and Cybersecurity Group. His practice focuses on the area of privacy, data protection, cybersecurity, artificial intelligence, and digital regulation. Welcome, Edward.
Thank you.
Next up is Sami, an associate in the privacy and cyber practice at Latham Watkins. He is based in London, and Sami has advised many of the world's leading companies on their most challenging, complex, and impactful cyber incidents and data privacy disputes. Sami, great to see you. Welcome.
Thank you so much.
Finally, very pleased to welcome Lupe Sampedro. She is a partner at Cooley. She's based in London, and she heads the cyber data privacy practice and has advised clients in industries including fintech, payments, financial services, technology, life sciences, healthcare, media, communications, retail, consumer industries, you name it. Lupe, it's so great to see you. Thanks for joining us.
Thank you.
All right, I'm pleased to turn this over to Patrick.
Thank you, Bruce, and thanks again for giving us, all of us, actually, the opportunity to have this discussion on what to do about the GDPR after a data breach, isn't it? And I'm feeling so honored having this lineup of speakers as panel members with Edward, with Sami, with Lupe. I promise you, this is gonna be a very interesting next 45 minutes in your life. First question, and I'm gonna direct that question to you, Edward. It is, now, 12 months later, because our last session was about a year ago, what have you experienced over the past 12 months as what you think the most surprising or interesting kind of development that for you when managing GDPR after a data breach?
Yeah, thanks, Patrick, and I'm very glad to be here. So as we probably would all attest to, there are many, many different interesting developments. The thing I will pick is non-legal, but it's something that is touching many of our clients across the world, and that is almost, as we see it, the kind of professionalization of ransomware as a service. So almost as a kind of plug-and-play products that you can buy on the dark web and use for nefarious activities. And what we are starting to see in one of the more interesting developments is that the individuals that are using ransomware are becoming increasingly kind of differing in their skill levels, to put it frankly. So whereas previously you could typically assume that the folks you were dealing with were sophisticated, had done this many times, and were thus predictable, what we're now starting to see is, to put it kind of bluntly, folks in their bedroom looking to use some of the ransomware tools that are available on the internet. And that's good in a way in that they are less sophisticated, they often make mistakes, they may not encrypt data, allowing you, after you've had a data breach, to recover much more quickly. But the bad side is that they are much less predictable. And there was a certain predictability when you used or when you dealt with large, sophisticated cyber criminals that, for example, they would delete data when they said they'd delete data, they give you the key back and so on. Now, with an increasingly wide range of actors in the ransomware space, that's much less predictable and can be a much greater challenge for organizations, together with all of the legal side of things.
Well, thanks for that. You've got any similar kind of experience, Lupe?
Yeah, I think that's very, very similar. And I also wanted to add something, which is that something that we've been seeing lately in the last year is that also an increase in supply chain attacks. So instead of attacking the company directly, the attackers are targeting basically a third-party vendor. And that can cause a huge disruption. There were very recent examples with, I think it was Panasonic, Equifax, but for example, CrowdStrike. Probably most of us, we suffered it, either because we're traveling or with issues in our companies. It wasn't a cyber attack. But an incident, it was a software update, but an incident on that third-party vendor in the end had an impact of a lot of global organizations around the world and infrastructure and everything. So that gives a sense of like, what is the impact when something happens to a third-party vendor like that? And one thing that came out after the CrowdStrike event is that many companies are now wondering what are their obligations in terms of due diligence on sub-processors, because many of the companies that were impacted by the incident of CrowdStrike, they didn't know that CrowdStrike was a sub-processors. So many are wondering, and we get clients asking, okay, what is the due diligence I should do? I mean, what is expecting from me in relation to my sub-processors? And I think that is really an interesting development. And the only thing that I will add, and I will not speak much more because otherwise I will take all the time, is like we need to be aware that it's not only GDPR notifications. We have a broad spectrum, a patchwork of security incident notifications now under DORA, under NIS2, under industry-specific, for example, if you're regulated, payments, gambling. I mean, we need to keep an eye on all of those because notification requirements of security incidents have really expanded, and you have a patchwork of obligations there.
Imagine. Thanks for that, Lupe. Sami, from your side, what's your kind of experience over the past 12 months?
Yeah, thanks, Patrick. I suppose it wouldn't be a question about surprising and interesting recent developments if we didn't briefly mention AI. So that'll come to me. And I guess we've seen sort of both sides of this, really. On the one side, we've got an increase in adversarial use of AI by threat actors. So here we're talking about powerful use of deep fakes and enhanced phishing techniques. And we've got recent examples in Hong Kong of the finance worker who was tricked by a fake video call into making a payment of, I think, about $25 million. But of course, another side of that is that AI models are themselves the target of attack with these sort of new and interesting techniques, model tampering, aiming to poison training data that all have, privacy and data protection implications. Helpfully, though, I suppose, to sort of balance that out, we are seeing some really innovative use of AI on the defensive side of things, AI-powered threat detection and monitoring tools. So, interesting, if not surprising, how quickly we're moving in this direction.
Thanks, Sami. Already very interesting kind of new developments, I would say, comparing that with 2023, definitely 2022, etc. So why don't we all together with the audience, we actually go back to, let's say, I don't know, the 31st of December or that last Thursday of November, Thanksgiving. So right before you're preparing for a great party, you already nipped a little bit of champagne, there it goes. And what happens in-house or as an external lawyer, you get that call, damn, they got into the system. Immediate reaction necessary, isn't it? Lupe, how do you react to that? And what do you need to do?
Well, I love what you say about New Year's Eve and Thanksgiving because it's always that. It's always It's always, I mean, and I think that the first 24 hours are really critical and for any organization. And if you haven't tested your incident response policy before, they can be a real challenge because you need to make sure that in a very, very short period of time, the first thing is that you need to have the team that is a cross-functional team around the organization, plus your outside counsel, an external forensic company, everyone working together as a team on the very, very first moment, because they are the ones that are going to be leading the organization through the data breach investigation and also the aftermath coming after the investigation. And then one thing that we see is that sometimes those functions have conflicting interests on the sense that the PR team that is going to be part also of that crisis, basically team of representatives of the company is probably more thinking about going ahead with the story. Then the IT and the InfoSec team, they can be a little bit defensive sometimes. I mean, the board, because you need to inform the board and tell them what is happening, their priority is going to be reassuring the stakeholders that everything is going to be fine. And the CEO wants to make sure that the company is operational as soon as possible. And if you're sitting in the legal team, that's all a challenge because at the same time, you don't know the scope of the incident. You only know that something happened. You are not sure about what happened. You are not sure about the impact of what happened. But you know that you don't have much time to react from a legal perspective. So you need to start working on assessing whether this may trigger any notification requirements depending on how it develops from a regulatory perspective. But there are three things I think that the legal team needs to bear in mind very, very quickly in those, and bear in mind, I mean, in these first 24 hours, which is, we don't know what happens, and we don't know if there's going to be litigation afterwards, or if there's going to be an investigation. So let's start thinking about privilege. Let's start thinking about privilege on the first hour when we are involved in this. Then second, find insurance policy. I mean, if you haven't been looking at it, you really need to make sure that if you need to notify your insurance carrier, you have to do it right now. What is the coverage that you have? If it's a ransomware, that is really key, because you really need to answer the question of whether the ransom is going to be covered by the policy or not. And also know your contracts. If the breach is happening on the vendor side and is impacting you, you really need to have done some sort of due diligence or start digging into the contract with the vendor to know, is the vendor going to pay for a forensic investigation? Is it going to pay? Are they going to pay for a call center to speak with your users? For example, if you have to do one, are they going to pay for notifications to individuals by register mail? Do you have audit rights that will allow you to gather information if they are not collaborating? You need to know your contractual rights and start looking at that, because that is really important and that is an input that the legal team has to give. And if you are the one that is suffering the breach, you need to know your obligations with your customers. When do you need to notify them the breach? Do you need to tell someone that within 24 hours, apart from being in the madness of investigating the breach, maybe you need already to tell your customers because your agreements say that. And the problem that we find a lot of times is that the legal team is usually under-resourced, and then every contract with every customer is completely different from the other one because they haven't been able to impose always their template. So those 24 hours are quite tricky. And at the same time, I mean, you're doing the forensic investigation and discovering as the forensic team advances.
Thanks, Lupe. Over to you, Sami.
Yeah, I totally endorse what Lupe just said there. And I guess, we're all sort of pragmatic operators, or we try to be. So, when we're looking at legal questions in the context of a immediately post-breach, we obviously that sets in the context of the business priorities and the requirement to get the business back on its legs. But as Lupe mentioned, in the background, what we're trying to understand or prioritize to some degree is understanding the scope of the impacts. And that, for us as, talking from a GDPR perspective, that's obviously going to focus around the challenge of identifying what data has been impacted in the course of a breach. And that's always quite an interesting challenge, especially in a scenario where we've got a network intrusion by a threat actor. With cases of data exfiltration, for example, evidenced in logs, we have a bit more of a clear-cut understanding maybe of precisely what data was impacted. So we could, start looking at that in order to understand what sort of personal data might be in there. But then we have the question of, what data might have been subject to unauthorized access, where, it might not be necessarily clear what necessarily the threat actor might have touched, where they've been in the environment, what they've interacted with. It becomes a bit more difficult to ascertain. So I can sort of think of examples from very recent memory where threat actors have managed to get access to, the hypervisor layer of systems, but it's not been clear fully, which virtual instances they've accessed, where the data ultimately sits. And I guess in cases like this, we're trying to understand quite quickly, really, what digital evidence we might have of things like hands-on keyboards activity rather than merely, an automated scan. And of course, we're going to be leaning heavily on our DFIR forensics colleagues to understand that. But the strategy is, I think, very much going to be guided by the response team and with these legal questions of risk in mind. So, your starting point is going to be identifying the types of systems that the threat actor appears to, show activity on. And then you start to build out the evidential picture from there, understanding bit by bit, to what degree the threat actor may have actually manually engaged with data, merely seen it, whether the activity was purely automated, and you can start to build an analysis of the risk that this data has in fact been exposed to an unauthorized access. And I guess, like most of incident response, this is going to be an evolving discussion with the evidence and the sort of rarely clear-cut answers that are available.
Thanks, Sami. These very first hours of the data incident, Edward, anything to add on that?
Yeah, the kind of elephant in the room here, and I completely agree with what the other guys have said, is that the clock at some point is going to start ticking on the notification requirements if it is a notifiable breach under the GDPR. And to take it back to the beginning of your question, that will often mean it could be over the weekend or it could be over holidays. And so just some practical thoughts on what that means. It is not necessarily always the case. Sometimes it is and it's clear, but there will be cases where the clock does not start ticking when you first become alerted to something that has happened. There may still need to be a process of evaluation to understand whether there is a personal data breach, the extent of the personal data breach, whether it has been remedied, whether it's ongoing, and so on. And that's not to say that you can get cute with your legal obligations. You know, if you are aware that there is a data breach, the clock starts ticking. But there is some wiggle room there and some kind of defensive posture to allow you to take a step back in what is, or, you know, as the guys have mentioned, a very high pressure situation. The first 24 hours to think, well, actually, when does the clock start ticking? And it may be that if you can buy yourself an extra 24 hours, you've got the forensics folks in, you've got the business folks aligned, that is a lifeline. You know, an extra day can really help you understand. And I think we'll come on to talk about it, but to present to the regulator an informed view of what is going on. And so there is always kind of a tension there of, well, do you report something that you don't really know about, or is it slightly better to understand what it is that you have on your hands and then make a more informed notification?
Thanks, Edward, for mentioning that, because indeed one of these kind of notification duties, and when actually is this kind of 72 hours deadline, when that clock is ticking, it's one of those every time again, recurring kind of conversations. And that brings me actually to the next question. But before doing that, I just wanted to notice there is one question that came in from the audience. When Lupe, you referred in the introduction, you referred to NIS, the NIS directive, and someone actually asked the question, hey, but NIS, that reminds me of the United States NIST, so the Standardization Institute. That's, of course, what you're not talking about. You've been talking about the NIS directive, now in its second version. Now, we, the Europeans, we call that NIS2 or NIS2, and that is actually the Critical Information Infrastructure Protection Directive. We could have a completely separate webinar actually on NIS2 and DORA, the Digital Operational Resilience Act. We're not going to do that, but I just wanted to actually mention to the great member here in the audience that Lupe, you mentioned, of course, NIS, NIS as an acronym.
And just a very quick point, Patrick, NIS should be implemented today on the day that we are doing the webinar. So yes. Happy birthday or birth to NIS2 to the member states that it's been implemented in. So it's very topical.
It's very topical, Edward. And you were also very elegant by saying they should have implemented.
Yes.
Because many of those they have not yet. So the European Commission is now actually preparing its letters to quite a few member states of the EU, telling them, hey guys, today was indeed the deadline, you should have transposed it into national laws. But again, yes, interesting, but that's not the topic of our session. It is what happens with GDPR after a data breach. So I would like to bring it back to GDPR, although it's becoming, as you said, it's a patchwork loop now with all these other different notification obligations from different other pieces of legislation, like NIS, like DORA, EIDAS, etc. But one of the questions, and I think all of us, we have received that kind, or have had that kind of conversations with clients, or also in-house. Many companies have that conversation. Damn, we incurred a cyber incident. Do we really need to tell anybody? Can't we just keep it indoors? Do we really need to have to go to the authorities to explain actually what's happening? do we really need to tell our customers or business customers, or do we also need to tell the end users, etc., etc.? So I actually that kind of tension between these notification duties and actually trying to keep it as low profile as possible. How do you deal with that, Sami?
Yeah, thanks, Patrick. Well, so Edward sort of covered a good amount of this, actually, and I definitely endorse that. I mean, I suppose one thing to be very cautious of is trying to be a bit cute with the arguments on why not to notify, because, you know, in scenarios where there are clear-cut evidence of a personal data breach, unauthorized access to personal data, you know, you're not going to have a very strong argument. And I guess that the risk on the one hand that people are trying to militate against is going to be the perceived sword of Damocles of the regulator, you know, wielding its 4% global turnover fines and everything else that sounds incredibly scary. But I suppose one thing that we're seeing a lot of is a more pragmatic approach from regulators where, you know, they're not looking to enforce and really slap companies who are the victim of breaches. But one thing that I wanted to actually pull out from my perspective, and I'm sure the other guys will cover in more detail some of the other considerations, but in terms of the early tensions in a GDPR perspective, notifications more generally, because incidents are nearly always multi-jurisdictional challenges for organizations nowadays, we have a lot of different stakeholders, regulators, DPOs in different locations, different business units. There's a lot of different tensions at play. And sometimes we find that global businesses are very eager to discharge what they perceive to be their regulatory obligations quite quickly, but not necessarily thinking about the contagion risk and cascading impacts. Now, of course, as Edward has said, you know, you're not going to be able to avoid the black letter of the law where it's nailed on, but a note of caution there, because we often see, you know, challenges arising where organizations are not fully joined up. And we sort of hear midway through an incident that perhaps a business unit out in a different jurisdiction has proactively notified their regulator, and maybe without having fully nailed down the facts, without having, you know, at least being singing from the same hymn sheet. So, you know, while there is the tension of navigating the black letter law, that also is balanced against the commercial risk that comes from notifying in certain jurisdictions with, you know, different trigger points and different thresholds, and regulators communicate. So that's the thing to bear in mind, I suppose. And, you know, news gets out, and it's not ideal to be on the back foot when you're speaking to someone like the ICO or a European regulator who has learned about a breach that's been reported elsewhere, and so they're learning through a third party. So I guess for me, ensuring a joined up approach proactively is really quite important when you're coming to considerations of notification. And that involves really, practically speaking, getting a lot of buy-in from the top down early, in terms of properly mapping out your escalation processes internally, your procedures. These are all big levers to pull to kind of avoid the risk that a business unit will sort of jump the gun a little bit. But that's something that I wanted to kind of pick out for the early tensions with respect to notification obligations.
That's great, Sami. I don't know, Edward, you got anything to add to that?
Yeah, so endorse all of that. I think as those of us both on both sides of the kind of company divider and visor side who have drafted and reviewed multiple notifications, you will know that it's both art and science, right? There's not always a kind of template to this. From the regulator side, I totally agree with Sami. Consistency is key. I think almost a fairly kind of unemotional, dispassionate. You can report what you know. It's not necessarily a problem to say that an investigation is ongoing and you need further information, rather than trying to kind of overpromise and underdeliver. And then on the customer side, I think that is slightly more kind of nuanced, and we see examples, and we saw recently one that Lupe mentioned, where actually, do you need to think about being slightly softer to your customers? If you were the one that has experienced an incident, messaging that to them in a way that is, you know, compassionate and clear about what has happened, whilst also kind of straddling the line of not admitting liability or having kind of language around that. So it really is a kind of nuanced process. And like Sami says, the more stakeholders you have without kind of overcooking it, I think is helpful. So you don't have an overly legalistic approach or an overly kind of marketed approach. The only other thing I would add is that something we've seen increasingly is that you file a notification to a regulator. You don't hear for 2 months, 3 months, 6 months, 12 months, and you assume that everything is done. And actually, particularly from some European regulators, we are having clients who receive follow-ups, up to a year later. And sometimes that feels scary. Sometimes it's them just kind of working through their process and their backlog. But it's not always a kind of file and forget. It's always worth kind of thinking that, we need to anticipate that there may be follow-up at some point in the future and have that in mind.
No 72 hours clock for the data protection authority.
No, if only.
Lupe, I know that you're well experienced and well versed in this kind of global data breach notifications. You got any kind of things to share with the audience?
Yeah, I fully endorse what Edward and Sami have said. This is the same experience that we have. I think that it's really important to know the jurisdictional scope of those breaches, because you may be thinking first on only notifying GDPR countries and your 72 hours, but it happens that some data protection authorities in other countries globally may also have you may also have an obligation to notify to them. And in some countries like Korea, you have 24 hours. So it's quite really short deadline timelines. And the largest breach I have managed was 140 countries and territories. I learned a lot about geography, but I also learned that there's not a one-size-fits-all. So it's a nightmare. If you have to notify, not only, in Europe, and you know it, Patrick, 27 member states, different languages, different forms, different ways and methods of sending the notification. Sometimes an email, sometimes you need to use a different platform, sometimes you need an electronic signature. Doesn't make things easy when companies are under so much pressure. And then if you look at it globally, it's the same. Each country has their own notification forms. There are questions that are going to be repeated in all of them, but there are many that are different. And when you look at notifications to individuals, it's also different, because in Europe, I fully agree with Edward, and in the UK, you would follow that approach of notifying that way. Giving the facts, but not creating like unnecessary alarm. While in the US, you have to give so much detail of information that the notification and the level of information that you're going to share with your users is going to be different sometimes, because it's going to be mandated by cultural requirements and also regulatory guidance. In some countries also you will need to send registered mail letters. In others it's going to be enough with a banner on your website. In others you're going to send an email. So all of that makes it really, really difficult to manage, because it's a lot of work streams happening at the same time. And I have had the same experience as Edward. Not only in Europe, also outside of Europe. 1 year and a half later, getting a letter saying about that breach. And you give us this information, and it's like, now out of the blue, but yeah, it happens. It's difficult.
Thanks, Lupe. Now, we all know data breaches, they come in all kind of forms and colors, like the rainbow. Of course, we've got the definition of the GDPR, and it's a very broad definition. I just want to read it here so that we are all aware what actually, when we talk about a data breach in the sense of a GDPR, what it means. And so the definition is, it's very straightforward, but very broad. It's a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. So it's a very broad definition, and indeed it could be data leakage, it could be any kind of things. I want to focus for the next question, and it's a question I'm going to go to you, Edward, to one very specific kind of thing that is really very, very stressful for most companies, which is about ransomware. And I think, Sami, you already mentioned that during the introduction, we see, or someone else mentioned that at ransomware, we see more and more of these kind of things coming up. How do you need to deal as a company, knowing you've got this, it's happening now? What do we do? Are we going to pay or not? Edward, how do you deal with those things?
Yeah, so this, like you said, is one of the most kind of interesting but also challenging areas for companies, because it involves both legal and non-legal considerations. Sami mentioned that there is often a business imperative to dealing with a breach, that will drive what the company wants to do beyond purely the legal regime. So speaking from the position in the UK, and I won't touch on sanctions and all the other issues around paying kind of sanctioned and prohibited entities, but the ICO kind of repeatedly says that paying a ransom is not going to act as mitigation. And so on the one hand, you have that prohibition or that statement, it's not going to help you in the event that you do. Versus sometimes the business reality that a business needs to pay a ransom and makes a commercial decision to do so, and so it's weighing up that assessment of whether you pay. If you pay, does that then mean that people will come back to you again and again because they know that you will pay? And it's really kind of really a case-by-case decision. Like I mentioned at the top on the ransomware piece, particularly when you're dealing with unsophisticated actors. Having some kind of reassurance that if you pay them, they will do what they've said that they will do, the kind of honor amongst thieves is a challenge with certain kind of much larger, sophisticated ransomware organizations. You kind of knew that if you would pay, that you would get the data back. So there's the challenge. We have talked about NIS 2. I will just have a very quick plug for a law that is coming up in the UK post-Brexit. Obviously, NIS and the kind of European regime has not directly applied here, but the new Labour government has introduced or is going to introduce a bill that is similar to NIS 2. And one of the provisions there that viewers might be interested in is that there is going to be, we think, obligations around notifying ransom payments. And so the key question here is that something you do afterwards? You notify the competent authority or the government so that they can get an understanding on the ransomware industry, or is that going to be more akin to a licensing payment? So before you make a ransom, you have to notify the government and get approval. If the latter, that's going to be really challenging and something for businesses definitely to be aware of. So it's a kind of complex picture, but like I said, case-by-case basis every time.
Thanks, Edward. Lupe.
I fully endorse everything Edward has said. And I think that the proposal from the Labour government is aligned with the debate that we see in many other countries around the globe. Governments want to know which companies are paying ransom. And they want to have a sense of what is the size of the ransomware industry. And I was reading, I have it here, I was reading the other day on a statistic, I don't know how accurate this is or not, but it said that 71% of global organizations reported ransomware attacks last year. And the important thing is that they said that 62.9% paid the ransom. So, I mean, there's a commercial reality, as Edward was saying, in relation to ransomware attacks. So in those circumstances, I think that is also needed to have a ransomware firm supporting with ransomware negotiations, supporting with all that process. If you decide to go on the route of like negotiating the ransom and make a payment, I wouldn't know how to pay 5 million on crypto, to be honest. So I think that you need to use some of that support. And again, I was talking earlier about the insurance, and the only thing I would say is like, obviously it's very important, I mean, to know the scope of your insurance policy. I mean, insurance covers payments of ransom, but also will depend on many circumstances. I mean, you will need to do your due diligence, you will need to do sanction screening, I mean, to make sure that you are not getting into trouble paying the ransom. And also the track record of the company. If we had a ransomware attack 1 year ago and the company didn't fix anything, they used insurance, they paid the money, that was it. Edward was saying earlier, I mean, look, I mean, unsophisticated threat actors, I mean, may think that this is a way of getting business. I mean, the company paid once, they haven't fixed anything. 1 year later, they go into the system, they find the same passwords, the same systems, the same everything, they go again. And maybe at the second time, the insurance is not so happy to pay, because if they see that nothing has been fixed in that time, in that period of time of 1 year, that the company has had the same issues from a security perspective that 1 year before, that there hasn't been any readiness, investment or readiness in the company, no tabletops, anything, maybe you cannot rely so much of your insurance is going to pay.
Thank you, Lupe. Sami, any practical advice from your side?
Yeah, I just pick up very quickly on two things, one that Edward said and one that Lupe said. It's super interesting challenge with regard to threat actor attribution and understanding who is on the other side of the negotiation table, making all of these issues, you confounding them horribly. And really interesting again from Lupe with regard to the threat of a secondary attack if you've not successfully mitigated the attack vectors and the risks themselves. But from my perspective, I just want to come at this a slightly different angle and say that it's actually quite hard to overemphasize the importance of robust and maybe even air-gapped backups on nullifying the pressures exerted by a ransom demand. I mean, at least in my recent experience, and I'd love to hear what you guys think about this. But one of the prime movers in the decision about whether or not to pay a ransom is whether you can get your business back on its feet, straight from backup. And at that point, if you can recover without the need for a decryptor key, the demand for payment is far weaker. And you're really just negotiating for time with the threat actor. Just stalling for time so that they don't leak the data on the dark web or notify people. And we've seen some really bizarre action from threat actors in recent months and years who are not merely leaking the data on the dark web, but also reaching out to family and friends of CEOs to tell them that there's been a major cyber attack. So that's a very interesting pressure point. Also, from a GDPR perspective, having the backups available to, quite rapidly, hopefully, restore your systems is going to, at the very least, mitigate against the harms that flow from something like a loss of availability of the personal data that was impacted in the attack.
Thank you, Sami. We've got less than 10 minutes left. We've got a few more questions to cover, and I want to stay with you, Sami, on the next question. So the heat is got decreased, so we're out of the 72 hours 1 week later, and now we're actually starting to realize what has happened and what should we continue to do. What did we do wrong? What actually we did well? What about liability related issues? We are getting more and more phone calls from customers who say, hey guys, we were out for 48 hours and that costs us money. So what is your kind of reaction to that, Sami? How would you advise clients on the next steps in a kind of data breach?
Yeah, absolutely. And I guess, unfortunately, the kernels of liability where they originate sort of all crystallize within the first 24 to 48 hours and then propagate thereafter. So when we are sort of out of immediate incident response mode and maybe the business is back to trading, that's when you sort of look retrospectively and hope that you did everything right with respect to mitigating liability risks that kind of then play out over the longer term. So perhaps I can slightly reframe and just pull it back to kind of where the liability tends to arise. And I'd say that in truly large scale breach work, so much critical information is discovered in those first hours, days, weeks, which will then help you understand the liability position and start to kind of map out your legal risk, whether that's regulatory risk, whether that's counterparty risk against contractual counterparties or suppliers, vendors. So I guess right from the very get-go, a really robust fact-gathering effort is quite important now. It's very important, really. Document management, all protected ideally by legal privilege, so that you can understand and freely map out where you think that the risk factors are likely to originate, and over the longer term, manage them appropriately. I suppose there is one other thing to mention there is, where liability over the longer term tends to originate from is your crisis communication. So it's the information that you put out via media channels, via your business, or what you say to law enforcement, public, really any stakeholders where you're communicating that's not internal within the privileged group. That language, it gets tested and tested and tested over time, and it will be used in litigation. I'm sure further down the road it will be the thing that you have to stand behind ultimately. So I suppose that's my bid, to kind of really focus on the use of words, not overstating the facts, but not being manipulative. We've seen in the US side of things where organizations have been criticized for perceived misleading statements that present things like ransomware attacks as IT issues, obviously not correct. So this use of language very early on can actually spin out into some really serious litigation risk further down the line.
Well, thanks for mentioning that indeed, Sami. And I'm going to ask a question related to class action suits, because that's a new thing that is coming in. And I'm going to ask you, Edward, and then as a follow-up, you, Lupe, to that on that question. So, because you just mentioned, Sami, that there is this kind of increased risk of litigation. And we in Europe, at least here on the continent, we are not used to what has been called class action suits, collective redress mechanisms. But the world has changed, especially after Dieselgate. And so we do see now that the European Commission has initiated some time ago already with a new piece of legislation that finally, slowly is getting transposed in the different member states. But the world of class action suits, redress, has changed, I would say, isn't it, Edward? Also from a GDPR perspective.
Yeah, that's correct. And I realize I'm speaking to folks who have one of these working in the UK courts. So I defer to you on the specifics of it. But the UK, much like in the EU, has been historically kind of reticent to what they saw as kind of US class style litigation and everything that went along with it, the huge verdicts and the kind of ambulance chasing side of it. And so when the GDPR came in and the UK GDPR, there was a thinking that some of the new provisions around allowing for group actions and so on would result in a kind of avalanche of these claims. And we haven't seen that. That's not to suggest that claims can't succeed, and particularly I think where a regulatory finding has been made, kind of follow-on claims are likely to have more success. But the UK courts, at least kind of historically, have in certain of the cases that might succeed, for example, in the States or in the UK, in the EU, sorry, taken quite an interesting position that there are certain facts of life in the digital age that do not rise to the level of harm or kind of threat that would involve a class action. So, if your email address gets sent to the wrong person, that does not then allow you to mount a class and so on. So, like I said, defer to the experts here, but it's an evolving picture in the UK and one that's certainly not kind of finished.
Isn't it, Lupe?
The EU, I mean, the situation is a little bit different from or the situation or the future is going to be a little bit different, Patrick, as you were saying, to what we're used now. Because I think that we have a combination of two factors. On the one hand, the European Court of Justice, I mean, they had, in the last year, I think there was 5 rulings about individual compensation for non-material damages for breaches of GDPR. That combined with the new collective redress directive, the directive that you were mentioning earlier, Patrick, I think that we're going to see more class actions because it's going to be easier. I mean, with the new directive, what the new directive allows is a number of organizations, I mean, qualified organizations. I mean, each European member state will say which are those qualified organizations, but they're going to be mostly consumer associations, will be able to represent individuals across different European member states claiming compensation for a breach of the GDPR because GDPR falls in the scope. And the member states will decide whether they want an opt-in or opt-out regime. So we're going to have forum shopping, and because obviously those qualified organizations are going to go to countries where they have a most favorable framework, and we're going to see more class actions, I think, than what we used to.
Like what's happening now in the Netherlands.
Exactly.
Good. Thank you for that, Lupe. And that is definitely something when we do the next webinar in 12 months, we're probably going to be reporting on ongoing class action suits throughout the European Union. I see, Bruce, that you joined us. So that means that we're coming to an end. I would actually want to ask each of you, Sami, Edward, Lupe, you got 10, 15 seconds, not more, to actually to tell the audience what's the most important thing that they should take away from what you just shared with them. Over to you, Sami, first.
Yeah, sure. Well, I mean, obviously, this is going to sound a little bit self-serving, but I think leveraging counsel is quite a powerful mover in incidents, even if just for a sense check. Breaches and cyber incidents are not merely technical challenges, so they don't just sit within the CIO and the CSO teams. They're operational, reputational, legal.
Thank you. Edward.
I know it sounds hard, but stay calm. Don't bury your head in the sand. If you have an incident plan, follow that. keeping calm will help you to get through it. And then once you're through, you can learn from the experience and get better the next time.
Thank you, Edward. Lupe.
Readiness. Get ready. I mean, it will happen. It's not if it will happen, it's when it will happen. So get ready for it. Test your security incidents program and see if it works.
Thank you so much, the three of you. Over to you, Bruce.
Right on time. Well done, Patrick. And great panel. Thank you so much, Patrick, Lupe, Edward, and Sami. That was terrific. We'll be back in 5 minutes with our next panel called Global Incident Response, Managing Incidents Impacting Global Enterprises. Thank you all.
Great. Thank you, Patrick.